Hello, this is Dr. Chad Kish. Welcome to the Week 6 virtual lecture for PEP 410 PE Standards, Law, and Classroom Management. This is Unit 3, Educational Law, and we're going to be in Part 2 today. You should take notes on this, actively participate as well as you can in your thought process. If you have any questions, you can email them to me. And pay close attention to the video portion, which is the PowerPoint slideshow, and the audio portion, which is basically a lecture I would give in class. We don't have the opportunity for as much back and forth or any back and forth here, but note any of your questions, and you can either email them to me or meet with me during office hours next week, and we can discuss them. So this is Unit 3, Educational Law, Part 2 for PE Standards, Law, and Classroom Management. We're going to be in the Educational Court Cases and Federal Documents for Week 6. Make sure you have followed up and completed your study.com foundational material, your reading and quizzes for that. And we will get into our material next. So we started with our history of education in America. We'll get into educational court cases and federal documents this week. Next week, it's going to be Part 3 and Part 4 together. School system governance, which is how school systems are set up, boards, and how the community runs it, the state runs it, federal government's role in education, as well as special and inclusive educational laws. You've got a lot of that in the adaptive PE class. And then our last class will be application of laws in PE, as well as your case study presentations. So tonight, this is basically our outline, our topical outline of what we're going to go over. Start with, remember, court cases are when law could be applied from a previous legislation that the court gets involved and figures out how it could be applied, or it could be where courts determine different things and laws get made by what's called case law because of precedents. So we'll start with a nation at risk. In that report, we'll go deeper into what we started talking about last week, Brown versus the Board of Education of Topeka, Kansas. We'll talk about the Education for All Handicapped Children's Act, Goals 2000, the Individuals with Disabilities Education Act, or IDEA, the Moral Land Grants Act, the Legacy of Lloyd Gaines, which has a Lincoln University tie. There'll be a video. It probably won't play within this. I'll put the link also in our hybrid day, our virtual learning day. Make sure you watch that link. It's just a real short video, and it really hits home with Lincoln. And I'd like to talk about the legacy of Lloyd Gaines next week. The No Child Left Behind, or NCLB Act, as well as the Every Student Succeeds Act, which is the ESSA, one kind of transformed into the other. We'll get into Tinker versus Des Moines Independent Community School District, which is a landmark case law. And then we'll talk about Title IX and gender equity. So let's start here with a nation at risk. In 1983, President Ronald Reagan's office released a report. He didn't write it, but it was a 36-page special report written by a special commission that examined the state of public schools in America. And this report was titled A Nation at Risk. The report detailed the American education system. It stated that there were declining test scores, that a lot of this was because of possibly our lower ability for teachers due to low teacher pay. People were getting out of the industry, which still is occurring today. And then there's still a high rate of illiteracy in the country when people were tested. The recommendations, remember this report was in 1983, was to increase rigor, to make courses contain things that were more rigorous, more challenging, to increase the standards, to develop new educational standards, that these standards would then add some kind of goals and objectives that set a higher level of learning, and try to increase teacher pay through teacher preparation and educating teachers to be better at their job. The impact on education, it led eventually to the Common Core standards, which were known as the Common Core federal standards or national standards, and these were core subject areas as well as PE was involved in this, and they were the standards, not just like NASP standards. They were more like the grade level expectations written in that format for all of the different subjects, really written at the national level and then sent to states. And that's what states were supposed to test people on when we had the accountability legislation, such as No Child Left Behind and Every Student Succeeds Act. Uh, Eventually, the federal government didn't have enough resources, and the concept of the state should be able to set their own standards, and communities. Most of the funding for schools are done by the communities, and the school boards really govern the schools when we get into school governance. The Common Core standards, after a while, dissolved, and they became state standards. And really, a lot of that was was taking the federal standards or the Common Core standards and adapting them to a few things within your state. And most states didn't have the resources to redevelop them, so the Common Core standards really just got passed on to the states, and they've adapted and evolved a little bit over time. So the one thing, some people thought, they did some critics of this report. The critics stated that the report was really a manufactured crisis, and it wasn't accurate. A lot of the things weren't accurate. A statistical analysis showed that the declining test scores that Reagan was concerned about might not have really been declining after all. The test results of the 80s tested all students, but they were compared to previous test scores of only subgroups. So when you looked at the 1970s and 60s and 50s, the students that were tested might have been only white or upper class students, mostly males, students with access to top-notch education. When we get back to the 40s and 50s, there, when we study Brown versus the Board of Education, black students weren't even in school at the time. So people that couldn't read weren't tested. So students in urban areas might not have schools, and major rural areas might not have schools. So there were only really subgroups tested. So when we compared scores, we were comparing scores of everybody, including students with disabilities, with a subgroup of people that probably had a higher educational class at the time. So this crisis might have been unfair, unreliable, uh, an invalid way to compare data. One of the most famous cases in educational law is Brown versus the Board of Education of Topeka, Kansas. This was a case that basically conglomerated a bunch of different cases in a bunch of different states, and it ended up in the U.S. Supreme Court. So this was in 1951, and it came out of Topeka, Kansas, is where the case originated. But like I said, a lot of other cases kind of got tagged into it and enveloped into it by the time it got to the Supreme Court. It claimed that placing students into separate but equal public schools was considered race-based segregation, and that violated the Equal Protection Clause of the 14th Amendment. If we remember, for a case to get to the Supreme Court, it has to have some kind of U.S. constitutional tie or alignment. So the 14th Amendment is part of the U.S. Constitution. By violating that Equal Protection Clause of the 14th Amendment, it would make this race-based segregation unethical and unconstitutional, and that there should be no separate but equal schooling. Students should be able to go to the same school. If we remember this, we talked about it last time that a student wanted to go to an elementary school that was down her street, but it was an all-white school, and she had to be bused all the way across town to go to a black elementary school. So this was then challenged by the Plessy versus Ferguson ruling on school segregation that stated schools could be separated by race as long as they were equal in quality. So there was the original case against the board. It challenged this Plessy versus Ferguson ruling on school segregation, and it went to an appeals court and back to another district court and all the way up to the U.S. Supreme Court. So the district court originally ruled in favor of the Board of Education. They stated that the school district was abiding by the current precedent set by Plessy versus Ferguson that school segregation could be schools could be segregated by race as long as they were equal in quality. So they upheld uh, the verdict in favor of the Board of Education. So this is one that got overturned when it got to the Supreme Court. By the time the case reached the U.S. Supreme Court, it combined cases from various students, various school districts, and various states. So for it to make it all the way to the U.S. Supreme Court, it had to be related to a constitutional question or issue, and it was because it was related to uh, the 14th Amendment and the Establishment Clause. So the Supreme Court heard the case in basically looking at the 14th Amendment. They looked at the previous ruling, and they unanimously voted, which made it a landmark case, in favor of Brown and overturned the ruling for the Board of Education. They said the student should be able to go to the school in their neighborhood, even though it was considered separate but equal. This ruling, because the Supreme Court really writes down how they came to a ruling. So in the ruling, they explain that even though schools may be equal in tangible things, even though these schools weren't, so tangible could be buildings and desks and books and things that you could say that there's equal value and put a price tag on, that intangible aspects would never really be equal. So that meant that the demeaning feelings of being pulled out of your neighborhood school and being shipped across town and being separated was an isolation tactic, and that even though the school was separate, it could never truly be equal. So the separate but equal philosophy was basically null and voided, and that's why they decided to overturn the previous court precedents in their ruling. This ruling denounced or overturned Plessy versus Ferguson and required schools across America to be integrated. So at that time, some states tried to block this, and they said they didn't believe in it. Plessy versus Ferguson had set a precedence. They tried to refuse to comply, but President Eisenhower sent U.S. military troops, National Guard and Army, to enforce the court's decision and require schools to be desegregated. Another important legislation of the day that goes back to some foundational uh, educational law was the Rehabilitation Act of 1973. This is the legislation that provides us with 504 plans. We're allowed to have IEPs, but some students that don't qualify because they don't qualify for one of those 14 disabling conditions can get services. So this legislation provided vocational rehabilitation services as well as special services for disabled individuals. The legislation basically extended and revised the authorization of grants from the Vocational Rehabilitation Act and expanded federal responsibilities for research and training program with respect to individuals with disabilities. So Section 504 of this legislation also extended civil rights to people with disabilities. Section 504 provides opportunities for both children and adults with disabilities in education, employment, and various other settings. It requires schools as well as workplaces to make reasonable accommodations. In schools, that could be a special study area, it could be assistance, it could be modifying instruction, modifying equipment, could be making sure if you have a school that has stairs that rooms are made available on the first level for students that can't get to the second level. You can't just exclude those from science class because we have all of our science labs on the top floor. So Section 504 provides educational services. It's a 504 services plan for students who do not otherwise qualify for services through an IEP. So if you remember, to get an individualized education program, you have to qualify under 14 qualifying disabilities. So the 504 program is an individualized program that helps provide services and supports. It's similar to an IEP because it's developed by a team, it's reviewed and renewed annually, it has goals, and it provides specific educational services and supports to help students meet these goals. So PE teachers should refer to the 504 plans How does it apply to us in the field? We basically look at these similar to an IEP. We determine our goals. We work as part of the team. We provide adaptations, accommodations, and modifications to ensure that the student receives a fair, appropriate education free of discrimination. So we do everything we can to provide them with services and supports to give them a fair and appropriate education to help them reach their goals. Another important federal act or federal law is the Education for All Handicapped Children's Act. This goes back to 1975. President Gerald Ford signed this federal legislation into law. It outlined that schools must provide required services for all handicapped students. And there were 6 important mandates of the Education for All Handicapped Children's Act. First of all, there were 0 rejects. Nobody could be rejected from this law. Everybody deserved a free, appropriate public education. If you see FAPE, that's free and appropriate public education. This is where it comes from in this law. The law states that every student deserves and is enabled to reserve this free, appropriate public education. If you don't have a wheelchair ramp, you must build one. If you have all of your science labs on the top floor and nobody that's in a wheelchair has mobility challenges can take science, get to the science lab, you're going to have to move that lab downstairs. Next, you have to have non-discriminatory evaluation. School districts need to try to identify and evaluate students that may qualify for special services through things like needs assessments, possibly having a tiered approach to these services, looking at different ways to assess students and refer them to get services, but not discriminating against them, trying to help them provide what they need. All right. This is where the law wrote in the Individualized Education Program, or the IEP, was first heard. It's a written plan outlining how the school will meet individual needs of the student. It is developed by a team of professionals, including the student when appropriate, the parent, special education coordinator, a building administrator, different classroom teachers if they're mainstreamed into general education. We'll talk about that next, as well as people that could provide different services to help the student. And that individual education program is written based on a curriculum, and it will help modify the goals and set up goals that are individualized, how you're going to assess those goals, and what supports, adaptations, and modifications are needed to help the student meet those. So the next thing is the concept of the LRE, or least restrictive environment, came out of this act. Students should be referred to services, but they should start in the general education classroom setting and try to stay there. And this idea is called mainstreaming, all right, in the LRE, least restrictive environment, with, just some supports or adaptations or modifications, as long as they can meet those curriculum goals. If not, then they might be uh, able to receive special services outside that classroom. They might be, have a class within a class type of setting where you're blending services together, or you might pull those students out and put them in an adaptive class, or even then possibly an adaptive school or clinical school or specialized program. But you want to start with that continuum of services with them in the general classroom until they can't really meet those goals anymore. Next, every student that is handicapped still deserves special due process. This provides checks and balances to the system. If an IEP said the student needs extra time, they can appeal it if they aren't given extra time to be able to get that extra time. Suspensions are handled with due process. Any student discipline needs to be handled with due process for students with disabilities, just as they would be with other students. And the last one of the mandates is parental participation is required in this. Schools must be in touch with parents. They must invite them to the IEP meetings. Anytime goals are changed, they're required to notify the parents and have them involved in the process. And parents are able to receive any information they request based on their student's plan. So when we get to 1989, the Educate America Act set some goals for the next decade, and that was Goals 2000. So in 1989, the federal government began an intensive evaluation of education in America. Some of this coming out from some of the different reports. It led to the development of the Educate America Act. This act had 8 major goals for education. It was approved in 1995 by President Clinton. It is called the Educate America Act, but a lot of times it's known as Goals 2000. And it's a federal legislation or federal act that provides specific goals and specific processes, procedures, laws, and funding for schooling in America. This has 8 goals. So let me give you the 8 goals of the Educate America Act. So these are the 8 goals that we wanted to have in schooling in 1989 is when we start the evaluation. 1995 is when it got signed into action. So we had 5 years to try to get these things under control. So every child should start school ready to learn. So this provided funding and services for preschool and early start programming, such as the Head Start programs, provided grants to fund some of those and support. So students would not just come right out of the home into kindergarten or first grade. They would have an opportunity to get some education before that and get a jump start on their program. It also was a big thing with kids getting a hot meal, trying to provide healthy, nutritious foods to younger students before they even got to school. The goal was to try to get schools to have a graduation rate of about 90%. Schools were encouraged to start programs. There was some funding for programs to improve graduation rates across America because they were down in about the 70% at this time. Another goal is to teach students how to use their mind. Critical thinking and depth of knowledge and Bloom's taxonomy became at the forefront, like project-based learning, some even more science, technology, education, like and math and things were really had a focus on that STEM education. Provide more professional development to help teachers continue to improve because education was changing, how to improve your instructional tactics, how to learn more about your content, how to really continue to develop after your college education. How do we improve our focus on STEM education to globally compete in math and science and technology? So it provided some funding and some different programs based on STEM education. So science, technology, engineering, and math programs received all kinds of funding to get equipment, to educate teachers to be able to teach this, the professional development, Project Lead the Way, and different projects like this were started at this time. Try to ensure that this wasn't just goals for school, this was Educate America. So let's try to find different programs to make sure that every adult in America is literate, which means everybody can read. So we have the basic adult education and literacy program that even is housed here at Lincoln University. That's a grant program that's funded through acts like this. Number 7 is schools should provide an environment conducive to learning. This legislation started things like Safe School Act to make sure schools were free of drugs and violence and weapons and other things that could make schools unsafe, and that there were some more parameters on what school safety looked like. And then try to continue to develop a relationship or a partnership with parents, because education wasn't just done at school, it should be done at home with the families. Try to involve parents in their child's education. The collaboration with families and community at home should be a goal of every school, to provide not just the academic information to children, but also help boost their social and emotional needs and make sure that they're carrying these lessons that they learned in school over into their home life. So another major federal act is the Individuals with Disabilities in Education Act, or IDEA. So IDEA was signed into law in 2004. It was an updated version It's what the Education for All Handicapped Children Act kind of morphed into. A lot of these laws, one kind of leads to another as time goes by because things are rewritten. So IDEA requires that public schools provide specialized services to all children with disabilities from birth to age 21. So now preschool programs, students were going to be able to stay in school longer. You couldn't just say, oh, they got to 12th grade, they're 18, let's push them out. There's still going to be educational programming, specialized services till people are 21. So IDEA mandated that public schools created those individual education programs for each student, but they had to have an eligible disability. So uh, there are 14 eligible disabilities. We went over that before. We can talk about that again later. But an IEP is a document. Remember, it's an individualized education program developed and agreed upon by parents, teachers, sometimes the students, uh, special education uh, personnel, your school administrator, your general education teachers if students are mainstreamed in the general education classroom, as well as a variety of specialists. Uh, the IEP describes the present achievement level, the present level of performance, the plop of the student, and then it specifies goals for this upcoming school year, as well as determining what supports and services would be needed to achieve those goals, and then how they will be assessed and how data will be reported. IDEA requires students with disabilities be educated in that least restrictive environment. So it starts with that continuum of services where students start in the general education classroom. They have an opportunity to be educated with non-disabled peers to the greatest extent possible. And if their individualized program doesn't mirror the curriculum of the general education program and goals can't be met in the general education classroom, then you look at some alternative placements. So there was some updated language from the Education for All Handicapped Children's Act. Uh, First of all, free appropriate public education was one of the major four focusing principles that was introduced before, but that was more defined and laid out in this law. The appropriate evaluation, so what assessments were used and where the appropriate evaluation would be to be able to place different schools for different services and how that had to be documented is laid out. It was a mandate. Uh, Parent and student participation in decision making. This parents are going to be more involved in the IEP process. They had to be like their notices had to be sent out at certain times. It required a lot higher level of that as well as transparency with the parents. And then some procedural safeguards to ensure that these specialized services were being provided to service to the students that required services, the adaptations, the modifications, how funding was going to be to get these different supports, how standardized testing was going to be handled, a lot of those different things. So, how do we apply IDEA directly in physical education? So IDEA requires that students with disabilities receive physical education services specially designed if necessary. So physical education is the only content area that's like detailed and written into the law. The rest of the content areas are more vague. Physical education must be a part of the IEP, right? You can't skip that. It can't be other related services. It can't be that they're with a physical therapist or recess. Physical education must be written into it and it must be detailed. We have specialized learning goals and objectives. So we must provide learning objectives that are tied to assessments and performance-based goals based on the student's current level of performance and tied in or aligned with the curriculum and that mirror as much of the general education students as possible, but we modify, adapt, and provide supports to help students meet those. We also need to consider how the students are going to benefit from this in their regular life. So the time requirements on PE are important. So time and related services doesn't count towards PE. You can't pull disabled students out of PE to go do physical therapy or occupational therapy. We have to like keep time on. If so much time's written in the IEP, we have to document that, and we have to, if it's not met in the school year, we have to provide extended school year programming, which is summer school. We need to have detailed supports and services. Those need to be written in the plan. We need to provide those, and they need to be designed to help provide that fair opportunity for these students to meet their goals. And the PE teacher must be a part of the IEP team. You might be part of the PE integration team and not sit in on every part of the IEP meeting, but you have to be a part of that team because you're going to have to set goals, set assessments, and work with a lot of the other people on the IEP team. An individual with disability could be placed in adaptive PE courses when the least restrictive environment, the general education classroom, no longer is safe for them. All right. Another reason you could pull them out of the general education course and transition them to an adaptive course or a special education type physical education course is when the student no longer benefits from the regular PE classroom environment. They're not getting social benefits, they're not getting benefits, they're not able to reach goals or do things that mirror the curriculum. So the last thing is when you start adapting this curriculum to design their goals, it should closely mirror what general students are doing. So if they can't do that in the classroom and you go through some alternative services by putting them in an adapted PE program, even if it's in your school, a specialized program, that adapted PE curriculum should closely mirror the regular PE curriculum and just consider how you adapt and modify and individualize it to then provide supports for the student. So they should be getting a same big picture goals and the same approach and a similar curriculum with just different goals. So the Moral Land Grants Act of 1862 is another one that's got some similarities with the Freedmen's Bureau because it provided funding as well as some land for colleges. But the Moral Land Grants Act provided lands to states to build colleges, and these colleges needed to be focused on agricultural, engineering, or military tactics. So when you hear of a school called A&M, like Texas A&M, they got money from the Moral Land Grant Act. They were agricultural and military, or agricultural and mechanical college. So you're going to see a lot of that still out there. And there are a lot of other universities that kind of had A&M in their name that now became like a state university. Anybody that was an Aggie, that was an agricultural school. So Kansas State was Kansas State A&M, and they were the Aggies, and they transitioned to different things. So this idea was based really on the idea that agriculture, farming, and ranching needed to be improved to continue to produce food for these growing urban societies and our population explosion, as well as we had destroyed ourselves in the Civil War and we needed to rebuild our military to be able to provide, you know, defense for domestic and foreign uh, anybody that might try to attack our country. And then engineering, we were moving into that era, so it was important to act on that and develop new engineering tactics because we were moving into uh, building cars, building tractors. We were moving into that era of developing things. So each state actually received a plot of land to build a college. They're called land grant colleges. And Lincoln is a land grant college. We are a federal land grant college here. Each state received 30,000 acres for each member of Congress that represented them. Now remember, the congressman in the House of Representatives is determined by the population of the state. So there are two senators, and then the congressmen are based on your population. So at that time, the eastern United States was more populated and got most of the land to use for colleges. The Confederate States were initially excluded from this act during the aftermath of the Civil War. And that was another thing that, like, even though they were trying to exclude them because those states pulled out of the Union and fought, but a lot of the slaves that were freed stayed in the area that they lived and lived in the South. So if you were going to, you know, exclude those states of the South, you were excluding colleges and excluding education to students of color and the underserved population of the southeast part of the country. So they were initially excluded, but when they reauthorized the act, they lined that out, and the Confederate States also got land from the Moral Land Grants Act. In 1890, the act was amended and it removed barriers for minority students. So states had to also prove that race wasn't a criteria in admission decisions, and they were required to establish separate land grant colleges for racial minorities across the South, uh, and those were the HBCUs. So this act was important in the establishment of Lincoln University. The 1890 revision to the act provided both land and then now resources, some federal funding, and Lincoln University still gets money from the Moral Land Grants Act. So make sure you watch the link to Lincoln University's history, the legacy of Lloyd Gaines. It's a short video, but I'll put the link up on our hybrid learning page. I don't think it'll play here, but maybe it will. The No Child Left Behind Act, also known as the NCLB, is an important federal legislation. It came about in 2001 as an educational reform policy. It required that public schools focused on standards and accountability, and everything was tied to assessments. It also was designed to make sure, or to help ensure, that students were educated by highly qualified teachers. Another one of these reform acts to state that schools would have to turn in their data to what teachers who were certified teaching, have their teaching certificate and were teaching the classes that they were certified for, and that schools would lose funding if they had teachers teaching out of their content area or uncertified teachers. So No Child Left Behind provided the federal government funding at this point for Title I programs. So this provides the federal government a link to school funding sources. So with Title I, they were given money to the schools, but if schools didn't comply, the federal government would withhold their Title I funding, and then schools would not have this money to be able to operate. So if schools didn't comply, they'd lose their funding. Title I funding is a major funding source for schools with high percentage of low-income students, and it helps provide a lot of the different programs, such as reading programs, Jump Start programs, students that are behind. What are the advantages of the No Child Left Behind Act? So there's some advantages and disadvantages. Anytime you have standards or norms, they provide some foundation and structure and a little bit of accountability. The standardized assessments that were used across the nation help provide accountability. And the idea was to get these assessment scores, to set some baselines, to look at trend data, and to really focus on improvement. But sometimes the outcome wasn't that focus on improvement, it was taking away the federal money. That comes into the disadvantages. So the idea was hopefully it would lead to improved teaching by having standards that had accountability. Now we had some data, we had some structure. We were going back to the standards and norms process of education to require schools to hire highly qualified teachers, to have funding now for professional development. We would lead to improved teaching. And then all this data would be given to the communities, because a bigger portion of the tax base for a public school actually comes from real estate taxes, as well as some sales tax, a little bit, some other taxes. But there wanted to be some transparency to communities so people would realize and understand how well their schools were doing. Some of the disadvantages of the No Child Left Behind Act is the standardized test set a national curriculum based on the Common Core, and people taught their content focused only on the test to try to improve test scores, instead of trying to teach all the different social skills and soft skills and skills like we talked about the other night. Is it just doing math that's important, or is it how we apply math to real life to be able to do taxes, or to be able to use geometry to cut a board to fit here, or whatever the case might be? So what happened is it led to focus only on the areas that were tested because that's where the funding was going to come from. So it led to a reduction in funding in subjects that weren't tested. So physical education, health, the arts didn't fit those core subject areas. So funding was reduced, funneled away. Sometimes even a lot of those programs were chopped down, and we're going to require less credits of those in high school, and require less of those programs, even have less of them. So the resources really dwindled, and funding went away for non-tested subjects. It also provided an unfair burden on some of the schools in areas that had a high number of individuals with disabilities because they were tested just like any other student, but they didn't get any access to extended time because it was standardized. Uh, in high minority areas, schools that had students coming in that were behind, maybe in urban areas or transient student populations, no matter what the school did and processes were, if students came in behind at a grade level, there was really, and that just continued to perpetuate, there was no way to catch them up. And if the federal government was then going to take away their funding source for the programs, they were going to be even more underfunded. Because if your funding comes from real estate taxes in the community and there's a high level of apartments, you're not having houses built, so your real estate tax base is even less. So it was really an unfair burden to underfunded schools. In 2015, the ESSA, or the Every Student Succeeds Act, replaced the No Child Left Behind Act. So realize NCLB came about, but it's no longer here. So if you're ever talking to educators, realize No Child Left Behind led this sweeping reform act, but now that's no longer even in effect. It's the Every Student Succeed Act since 2015. It's a federal legislation that provides a continued action on educational reform, but it was, altered some to provide a commitment to equal opportunities for all students. They looked at some of those disadvantages and said, what can we do better? And they rewrote the law. So it started, this federal legislation started as the Elementary and Secondary Education Act of 1965. It then was reauthorized as the No Child Left Behind Act in 2002, and then rewritten in 2007, and then now it is the Every Student Succeeds Act. So it's kind of reauthorization and updates of these federal legislations. So what was ESSA? It was designed to provide students with additional supports regardless of race, income, zip code, disability, home language, or background to receive a fair, appropriate, and free public education. So ESSA's primary goal changed a little bit. Instead of focusing just on test scores, the idea was to fully prepare all students for success in either college or to go into the career field or workforce right after high school. So some of the programming switched up to provide college tracks, to work on those dual credit courses, to get students prepared for college, writing, and all the things you need for that, and then to develop some of these other programs that were more cooperations with tech schools and local businesses to prepare people for the career field. So ESSA shifts the focus of the No Child Left Behind Act to more of a well-rounded education for students. Businesses were saying at this point, students don't have these soft skills. They aren't taught these things that translate to the real world anymore. Everything's just on a test. And these students that test real well don't have some of the skills we need. The good thing for us, how does it apply to health and physical education? Well, under No Child Left Behind, health and physical education really suffered due to the emphasis on adequate yearly progress and student testing of the core subject areas. ESSA shifted the focus to a well-rounded education, which replaces the idea that PE and health isn't that important or doesn't fall under the funding umbrella. It now considered there's no such thing as a core academic subject as far as this act. So since health and PE are part of this new definition of a well-rounded education, subjects are now eligible for funding through these federal title programs. Title I, low-income schools, Title II, professional development, and Title IV through the State Department of Education. So our career field, it really, ESSA helps apply funding improvements back to physical education and health. So another major landmark federal court case, one of you even wrote about this in your legislative review, is Tinker versus Des Moines. So that's Des Moines, Iowa. So it was a case that started at the state level and ended up as a U.S. Supreme Court case in 1965. And why did it get to the U.S. Supreme Court? It was based on First Amendment rights and how First Amendment rights were limited or taken away from students in schools. So the First Amendment of the U.S. Constitution, I know some of you aren't from the United States, but it offers Americans the right to freedom of expression without government interference. So basically, if the government does something that a citizen doesn't agree with, a citizen has the right to speak up. They can say that they don't agree. They can post it on social media. They get freedom of speech. They can write about it. They have the right to assemble as long as it's peaceful. And they don't have to worry that they're going to go to jail just because they disagree with a politician or somebody in the government. Now, the courts, what we have to realize is, have limited the scope of free expression through certain cases. For example, yelling fire in a crowded theater where there isn't really a fire isn't protected. That's not free speech. That's, you know, doing something to instigate a riot, all right, or to interfere with, uh, how things occur safely. So we don't want to do that. So that freedom of expression is somewhat limited, but there's still a lot of freedom. In other countries, you argue, with the president or whatever, you could be jailed almost indefinitely. So Tinker is John Tinker and his buddy Chris Eckhart. They protested the Vietnam War back in the 1960s by wearing black armbands to school. The students were asked to take the armbands off before they entered school, and they didn't, and they were then subsequently suspended for wearing the armbands in school. School administrators found out about the planned protest, warned students they would be suspended if they protested in any way, that it was going to be detrimental to the educational setting, and they suspended the students. So the U.S. Supreme Court, once it got to them, actually ruled in favor of the students. It was a landmark decision, as courts had almost always, at this point, sided with the schools in limiting students' right to free speech and free expression. Cases that followed this, though, have went back to limiting student expression in schools. Schools can require uniforms. They can limit anything that, this is an important term to understand, disrupts the educational environment, all right? And they can limit student expression and extracurricular participation, because that is not part of the school day. That is not part of the free, appropriate public education. You have to choose to participate. It's extracurricular. So when you look at some of these other things, and I know some of you are looking at cases, can you limit things, or can you ask students to stand during the national anthem? Extracurricular activities is not covered under First Amendment rights. It's something you choose to do. Another federal legislation that really impacted education is Title IX of the U.S. Education Amendments. And it really wasn't meant to really apply to athletics. That was down the list, but that's really where it's got most of the notoriety, and most people understand that that's where it goes towards. But Title IX of the U.S. Education Amendments of 1972, so it's actually, the law is U.S. Education Amendments of 1972, and this is one of the titles of it, Title IX. It made it illegal for any federally funded schools to discriminate based on gender. Right? So they can't use their funding to discriminate based on gender, or they could lose their federal funding. So here are the 4 areas outlined in Title IX, and you'll see athletics is number 4. So the first one is, you can't have sex segregation. You can't delineate things by sex. It made stereotyping and segregation illegal. This made the idea of gender-based PE classes against the law. So we have to consider that. We can't just consider single sex classes. Now we'll talk a little bit more about that, understanding it on the next slide. So you can't just dump all the females in home economics and all the males in an industrial tech or shop class, because that would be gender discrimination. It also allowed or provided rights to females that were pregnant and provided parenting rights. So sometimes some schools, as soon as they found out a female was pregnant, they kicked them out of school, put them on homebound. They could come back, and if they missed a lot of school because they were a new parent, um, they were going to be held back. So this provided some rights for pregnant students as well as some parenting rights. It provided legal protection for attending school. Before Title IX, a lot of students expelled pregnant teens and withheld educational services. Number three, it looked to put an end to gender-based violence within schools. So it provides protection against things like sexual harassment, unwanted comments, touching, and that could be, you know, employee to employee, employee to student, student to student. All of that was going to be outlawed by this. And number four was athletics. And that was kind of really an afterthought of the law when they wrote it, but schools needed to provide equitable opportunities for females to participate in physical education and sports and extracurricular activities. So let's understand Title IX. So Title IX, how do we apply it more in our realm of health and PE and athletics? Title IX applies to all programs and activities in public schools and universities. This includes conduct that takes place on school buses, during extracurricular activities, student participating in athletic programs, PE programs, classrooms. Title IX protects not only students, but faculty and staff in any federally funded education program. So this could be a K through 12 school, it could be a university, it could be a federally funded education program such as adult education literacy, it could be a federally funded preschool program. So schools, every school district and every university is required to designate a Title IX coordinator to ensure that you're following the processes, file the right reports, you'll take any of the complaints and have to consider those. Schools may not segregate classes by gender, but there are exceptions for single-sex classes. So let's look at these exceptions. Physical education classes can't segregate by gender unless they are classes that involve body contact. So if you're going to have wrestling or any activities that involve a heavy duty of body contact, a high degree, then you can segregate PE classes that way. Any class or even by unit that focuses on human sexuality. Just thought it would be much easier, especially in that age group, to teach this, the female and the male human sexuality. So I believe that's number two. And number three, choral groups. So due to the differences in vocal range, it was determined that choral groups in choir could be segregated by sex or gender. So let's look at Title IX and how it's applied to athletics. We talked about how it's applied to schools and education programs. So Title IX addresses the availability, quality, and types of benefits, as well as the opportunities and treatments that both athletes and coaches receive in athletic programs. So there are three aspects of Title IX participation, or how we apply it to athletics. Number one is participation. So we have to look at appropriate or proportionate opportunities. So Title IX isn't really a quota system. Every institution has different options, and we'll talk about those to look at this. We need to look at proportionate opportunities. If there are 60% of the student population is females, then you should have 60% of the opportunities be females. But if all those opportunity slots don't get filled, then you don't have to take away opportunities from males. There just has to be proportionate opportunities, not necessarily slots. So some people get a little tied up on that. Well, there's more men's sports than female sports, or this or that. Well, you look at the total number of opportunities to come up with that. So here would be an example. When I was a high school athletic director, we had 3 levels in our basketball program: freshman, JV, and varsity. And at the beginning of the year, for both males and females, we would have people come out for the team, and we would generally have to cut a few females from the varsity team, maybe a couple from the JV, if any, and usually not too many from the freshman team, to be able to have 3 full teams. On the male side, we would be cutting more people than we would keep at every single level. But sometime throughout the year, a couple years, some of the girls from the freshman team transferred, or they decided they didn't want to play anymore, or even with moving people up to different levels as people got hurt, or somebody might get pregnant, or injuries um, sometimes seem to last longer. With females and males, the recovery time's a little different, or parents decided that the game might be too rough on them, so they pulled them out. Our freshman team would dwindle, and we might not be able to finish our full season at the freshman team. Now, equal opportunities, if we were going on, we got to do the same thing for both genders, I would then have to stop playing the boys' games, and that really isn't what the law was about. We still had proportionate opportunities. We didn't then have enough females. We canceled some freshman games, maybe canceled the freshman level, but we had the opportunities there for the same amount of 3 levels. Another thing is, you can look at history of expanding opportunities for females. So if you look at, are there any other sports in your area that females might want to participate in? And can we try to expand these opportunities? Provide more levels, provide more education, provide more coaches, provide better opportunities, better facilities. Like, as long as you're making some improvements there and trying to expand opportunities. The last one on this, your C, when you're looking at participation aspect, would be the full accommodation of interest for females. So when I was in St. Louis, we pretty much participated, the school I was at McClure and University City and everywhere, we pretty much participated in every female sport. Some schools may not have field hockey or lacrosse. Field hockey was a sponsored sport. Lacrosse was still kind of considered an emerging sport. But when we did interest surveys at the end of the year, there wasn't enough interest for us to start any of the teams that was played in our local area that we didn't already participate in. So we had full accommodations. So we kind of met the participation. But if we wouldn't have done those interest surveys, we couldn't have proved that. So we could prove that we met the participation by having full accommodation. There's a thing called the 3-prong test. It's a compliance test to see if you're trying to provide participation opportunities. And you can meet any one of those 3 prongs, and that would be A, B, or C. If you meet any of those 3 participation guidelines, you're considering meeting the participation guideline. If you're in college, you look at scholarships. You look at equitable opportunities for scholarships to provide proportionate opportunities related between the genders. So you have to look at funding, you have to look at the number of spots that are on each team, and try to provide that proportionate, equitable opportunities between the male and female athletic programs. And then the third one is program components. So the program components is sometimes where people look at it and they're like, I don't know if that's equal. Well, you're not really looking for quantity. So the standard for compliance on a program component was one of quality, not quantity. So we're not necessarily looking at the amount of money spent on football versus the amount of money spent on women's soccer. because the equipment costs are going to be more in football. You're going to have more people on a football team, so the travel cost is going to be more. What you have to do is look at the quality. Is the facility in the same realm in your conference? Is it considered in the top 20% or bottom 20%? That you look at those, are the facilities similar quality? When you buy uniforms, are they similar quality? When you buy equipment, is it similar quality? When you provide contracts to coaches, are they on a similar level? Like if your contract is the most expensive for the men's basketball team in the conference, is your females in the top 10% or so of the conference? Like you have to look at those contracts, and then there's always a little bit of give and take on that. Are does the coach you're hiring bringing in, a lot of experience in this, that, and the other? So your program components have to have some kind of component of quality between them, and different sports that you have will match up with each other. So the actual amount of money spent on men's and women's program doesn't have to be equal. It could differ, as long as the quality of things such as facility services, uh, program resources achieve equity or somewhat parity. So in the three-prong test, a high school or college, under participation, they can meet any of those three parts. They can have a history of expanding, they can have proportional opportunities, or they can have full accommodation. You only have to meet one of those tests to meet participation. Then in college, you have to look at scholarships, and then all other programs, you have to look at program components and determine if the quality level is similar. So some people don't understand how to apply Title IX to athletics. They think everything's equal, 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 and that's really not how the law is written. So let's move on to review for week 6. We're going to do a brief review, then we'll go over the assignments, and your virtual lecture will be a little bit shorter. Make sure you watch the video on Lloyd Gaines. And we didn't have time. What we would have done if we were in class, we would have had some more discussion on this, a little more on the application. We would have also presented a couple of minutes on each of our legislative or legal briefs, and we would have worked on some interview questions. So make sure you're practicing those interview questions. Make sure you're working on your professional portfolio. Those things are going to be due a few weeks after spring break, so that's going to come quicker than you think. So, could you explain Brown versus the Board of Education? All right, could you say that it was a U.S. Supreme Court case, and it was a student by the name of Brown versus the Board of Education of Topeka, Kansas, and it became a Supreme Court case because it was based on the 14th Amendment, and basically it started by challenging the separate but equal idea of segregated schools in America. The decision on the case was unanimous, and it eliminated or overturned the lower court cases and kind of overruled a standing case of Plessy versus Ferguson, the concept that schools could be separate but equal. And it basically required desegregation in schools and education across America. It was a landmark desegregation case. How did the Education for All Handicapped Children's Act change education for individuals with disabilities? Well, first of all, it provided the language for a free, appropriate public education for all, including individuals with disability. It required non-discriminatory evaluation and placement and in services and identification. It was the basis for the IEPs, or Individualized Education Program, and it laid the groundwork for the concept of the least restrictive environment, the LRE, and that then led to the concept of mainstreaming. What do we know about the No Child Left Behind and Every Student Succeeds federal legislation? Remember, those are federal laws requiring standards and accountability in education. The NCLE started out with focus on core courses and standardized tests and the review of those, where the ESSA revised the law to include all other subject areas, not just core courses. and focus more on a well-rounded education. It allowed the states to then use the assessment data to determine how schools would be uh, uh, viewed as successful instead of the federal government. And then the education then for the ESSA, the mission was to provide a well-rounded education to prepare students for college and careers, as well as the ESSA provided funding for the Title I, II, and IV programs, and three programs that help provide a lot of different services for students to provide a fair education for students regardless of backgrounds. What is Title IX and how do you apply it in PE and athletics? So remember, Title IX is a comprehensive federal law that prohibits discrimination based on sex in any federally funded education program or activity. When we're talking about PE, we can't have just same-sex classes, especially at the lower levels, until we get to the idea where there might be body contact, or maybe in health if we're teaching human sexuality. All right, so that's the exceptions for physical education. In athletics, it's designed to eliminate, once again, sex discrimination. Uh, we need to provide equity in different things, and equity is applied differently than equal. It's equity and fairness. So we're going to look at participation. We can look at that three-pronged test on participation. Are we have, you know, equitable opportunities? Do we have increasing opportunities? And then have we provided all the opportunities that anybody would want that's a female? We look at scholarships at the college level, and then we look at program components to make sure that quality is similar. So we'll have a couple of assignments for week 6. I'll give you your to-do list next. So what do we need to do? So for week 3 or unit 3 educational law, week 7, section 3, which is actually sections 3 and 4. We'll have 2 sections. Don't just read one section and forget. You're going to complete study.com for school governance as well as special and inclusive legislation. So make sure you follow the course outline in Canvas, the handout I gave you that gives you what study.com information you're supposed to do, and make sure you have that all done by next Monday, February 24th. So the assignments based on this week's information, you're going to do your second legal or legislative brief, right? Remember, a legislative brief is a law made through the legislative process made through government. A legal brief has a case attached to it. So if you do a case law, somebody versus somebody, or when not necessarily always a case law, but how the case applies to a law, you need to use the legal brief format. 2 of you use the wrong format in the legal brief, right? So no matter what you do, you can choose either legal or legislative on this one, and it needs to be based on one of the concepts of a federal law. It can't be a state law. It has to be a case that went to the U.S. Supreme Court, if it's a law case, or a federal case, right? Some of you didn't work exactly on the historical component last time either. So make sure we're looking at a federal law legislation or a federal case like at the U.S. Supreme Court, or a case that is directly aligned with a federal law like IDEA or ESSA. So we're looking in the federal realm here. Do a legal or legislative brief and pick the correct format and outline. A legal brief has a court case. A legislative brief doesn't. It's a law. So follow that right format and turn those in. Do not use the topic that you chose for your case study. You can't double dip here. I'll give one of them will have to be a 0. So I had 2 different people do that on the first one. They picked a case study topic and then they did their first assignment on their case study topic. So I had to have you switch. So let's not do that again. I won't let you switch. You'll just get a 0 on one of them. So that's due Friday, your next brief. If you turned in an assignment, 2 of you did this, that had a bunch of your briefs together, look at your feedback to see what score you got. and then take that next brief and turn it in on the right spot. I'm not going to grade it in the wrong spot. So turn the federal brief only in federal brief. Some of you had all three of them conglomerated together on one page. So assignment number 2 is Sunday, and it's February 23rd. It's an exam, and it's an exam on Canvas. It's a Unit 3 exam. And exams, once you open the question, the timer is going to start. It's based on questions that you've probably seen on study.com or questions based off of what I've taught, right? Once you answer a question, you can't backtrack. It's going to be multiple choice or true and false. So there's selected response questions. You get 2 minutes per question, right? You can't use any other resources. You can use your notes from class, so don't have a second screen open. And this is an individual test. You need to do it yourself. Make sure you get it by the deadline, and the timer starts once you start, so make sure you get somewhere where you're not distracted and you have good internet. Make sure you're working on your case study assignments. So your case study is not due till March 2nd, but if you turn it in early and you want to present in class next time and get it over with, you can, and that way we can spread a few of them out. So the case study paper's coming up the following Sunday, and then the presentations will all of them that we don't get in, if we don't have any early ones, will be Tuesday, March 4th. And then make sure you have worked through all of the questions, and I know most of you haven't, because when I ask you, you act like you're a deer in headlights and you haven't seen this. Start working through the questions for your culminating assignment, your interview questions 1 through 15. Make sure you update your application letter. That's open. It's in the culminating assignment, so if you want to go to that module and you want to update it and submit that there, you can. And then I will, in the next few days, grade your resume and either give them back to you next Tuesday, or I will provide them back through Canvas for you to look at. And then make sure you're working on your professional portfolio. That's going to creep up on you. That takes a while to do. So remember, your legal legislative brief is the same assignment handout before. It's a one-page summary. Make sure you provide enough information. Don't skip on it. Make sure it's you summarizing things. Don't just copy and paste. You choose your specific topic, but on this one, it needs to be related to federal legislation or a federal case law. Make sure you use the correct legal or legislative brief outline. A legal brief, once again, is a case. It's got somebody versus somebody. A legislative brief is the one you use for a law. So closely follow that assignment format. Similar to the first one, look at your feedback from it first to see what I told you, and then work on your federal brief, and it's due this Friday. So look at your case study topic selection. Make sure you read into that, because some of you, I told you can use this, but then I had to follow it up because you did that in your legislative brief. So I might have told you can stick with this topic, but now you got to do a legal case on it. So you can either on that one too, make sure you use the right format. Are you looking at a law? Or are you looking at a case? It's more in detail. It's more of a 2-page research paper. You can have more than one source. Remember, you have to provide a 1-page outline of a presentation handout. So after you get your research paper down, you'll just bullet point the important parts under each of the outline things in 1-page maximum. And if you email it to me by Monday, March 3rd, I'll print it out. If not, you're responsible to bring 12 copies to class that night, one for me and one for all your classmates and one for you to present from. So closely follow that assignment formatting. You'll do the in-class outline and presentation based on your research paper. The research case study paper is due March 2nd on Sunday. You'll present March 4th, and that's going to be about a 3 or 4 minute, 5 minute, I think I have max presentation, so we can get them all in.